Hello everyone and welcome to Uncivil Law. For today's case, we have an eminent domain case out of the state of Florida. This is the case of Sabal Trail transmission versus 3.921 acres of land in Lake County, Florida. In this case, Sabal Trail is looking to install some pipeline and they need to condemn some land, specifically in this case 3.9 acres worth of land. And there's a question as to whether or not the condemnation was proper and as to whether or not just compensation was given. So we're going to review the case and review the facts, and let's get started with this. This case arises from Sabal Trail's construction of a 500-plus mile underground pipeline to transport natural gas from Alabama to Florida. The Federal Energy Commission issued Sabal Trail a certificate of public conveyance and necessity authorizing the construction and operation of the pipeline. So first thing you do is you need to get a condemnation from a government, and you got one from the federal government. It says because it's crossing multiple state lines, right? So you want to build one from Alabama to Florida, it's crossing multiple state lines. Obviously, there's a federal interest in that. So it's like, okay, let's get a statement from the federal government that we need to install this pipeline. So they look over everything and say, yeah, we need this pipeline. It's for public good to be able to move, natural gas from one place to another. So let's issue the certificate. And so that's what happened. Spermy the Cat says, who decides the format of the judgments? The judges do in tradition, really. It's no more complicated than that. It's just basically every court just copying off of every other court. It's the biggest game of telephone ever, where every judge is just writing the way every other judge writes to varying degrees. And, every once in a while you'll get a judge who writes in their own way, and sometimes they inspire other judges to write in a different way. So mostly it's just like the format is copying the grounds of other judges who have come before. So there's no strict way it has to be done. It's just, convention is basically the answer. So that's, and then more properly the judge themselves. So that's the answer to the question. The certificate authorized Sabal Trail to build a pipeline across the route where Sabal Trail held existing rights of way to much of the land needed for construction of the pipeline. For the remaining more than 200 miles of route, Sabal Trail needed to acquire easements from landowners to build pipeline across the landowner's property. Although Sabal Trail was able to negotiate agreements with most landowners to purchase the necessary easements, some landowners would not agree. Yeah, 20 people watching, 12 likes. Why don't the other 8 of you like me? Why don't you like me? What do I have to do to get your like? Please tell me what I have to do to like you. Get you to like me. Yeah. Well, yeah, I was discussing this in the lawyer pickup lines stream before. It's like every lawyer is well, let's say most lawyers I know. Most lawyers I know have a wonderful mix of ego and crippling self-doubt. So yeah, being validated is kind of important. Yeah, it's an interesting mix. A portion of the pipeline's route ran across property owned by Sunderman Groves, a company owned by Charles and Jane Sunderman, who did not agree to allow Sabal Trail to purchase easements on the company property. Sunderman Groves owns approximately 500 acres of land spread across various parcels in Lake County, Florida. Sabal Trail sought to lay approximately 1,335 feet of pipeline in a diagonal path across 40-acre parcel of Sunderman Groves property. To build the pipeline across the parcel, Sabal Trail sought a permanent easement that would allow it to install and maintain the underground pipeline and related equipment. The permanent easement also would guarantee Sabal Trail the right to bar the Sundermans and any successive owner of property from building any structure in the permanent easement area, allowing Sabal Trail to remove any vegetation in the permanent easement area, and permits Sabal Trail to enter the remainder of the parcel to access the pipeline and related equipment. The total area Sabal Trail sought to condemn for the easement was 1.5 acres. In addition, Sabal Trail also sought a larger temporary easement to allow for the construction of the pipeline, temporary easement covering 2.3 acres, which brings us to the total that we're talking about. Permanent condemnation of 1.5, temporary condemnation of 2.3 for construction. Fine. You're a good lawyer? Well, thank you. Thank you, Jan. I tried my very best. Yeah, I try to be a good lawyer, so thank you. I appreciate it. Yeah. Yes, lawyers need pats on the head too, and treats. Lawyers need pats on the head and treats. When Sunderman Groves would not agree to sell the easements, Sabal Trail sought to obtain the easements by exercising the power of eminent domain. Pursuant to law, Sabal Trail filed its condemnation action against Sunderman Groves. Sunderman Groves stipulated that Sabal Trail was entitled to easements under the law. The parties continued to litigate about the amount of compensation Sabal Trail would pay for the easements. Because the parties could not agree on the amount, the district court held a jury trial on the issue. So the issue now is not the propriety of the condemnation. The issue now is the amount that is due. And so when you don't have an agreement, you need some sort of trial because it's an issue of fact, like how much is the land worth? And so submit it to a jury seems like a reasonable thing to do. So, okay, let's press on. Yeah, uncivilians. Yeah, uncivilians is, uncivilians, Jan, Jan, uncivilians is now the preferred nomenclature for us as a collective group. You are an uncivilian, we are uncivilians. That is now the preferred nomenclature for the group. We decided this last week on Twitch. So that's, we are all uncivilians. You are an uncivilian. During the course of the 4-day trial, the jury heard evidence about the value of the land affected by the pipeline and the appropriate amount of compensation for the taking of the land. The parties agreed that Sunderman Groves was entitled to compensation for the land taken by the permanent easement, the value of the land taken for the temporary easement, and due severance damages too. Is there a conflict between being a lawful master and an uncivilian? I'll get back to you on that issue, but in the event there's ever a war between me and Leonard, you might want to decide which side you're most loyal to. Ha 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 ha. No, don't make me decide. Don't make me decide. Yes, you will pick side. Blah. So in the event between me and in the event of me with a spat between me and Leonard, you have to figure out which side you're really loyal to. Blah. At trial, both Sabal Trail and Sunderman Groves presented expert testimony from real estate appraisals. Sabal Trail's appraiser opined that the total compensation owed to Sunderman Groves for the condemnation was $56,800, $8,100 for the value of the land taken by permanent easement, $5,000 for the value of the land taken by temporary easement, and $43,700 for severance damages. To calculate the severance damages, Parham compared the value of the remaining 40 acres of parcel before and after the taking. In conducting the valuation, he determined that the parcel's highest and best use was rural residential development with a parcel subdivision into 2 lots. Parham explained the parcel, which consisted of approximately 26.5 acres of uplands, could be subdivided into no more than 2 lots because local zoning regulations require that each lot have at least 10 acres of uplands. After considering recent sales of similar lots, Parham opined that prior to condemnation, the parcel was worth $7,000 per acre of uplands. So one of the issues here is that this pipeline is splitting an existing parcel of land. So if you're giving them a permanent easement over the entire pipeline length, which I suppose is something you can do, then you've effectively created 2 parcels, right? Because you can't build anything on this land. It has to remain vegetation free, so no one can build anything there. So you're effectively creating 2 parcels of land. So it's like, well, we're going to give you money for the amount of land we're condemning. So that's a value. And we also have to give you money for the reduced value of the 2 properties now separated versus 1 combined. Because 2 properties of 20 acres isn't necessarily the value of 1 property of 40 acres, right? So there's value differences there. So because we're severing the land into 2 separate parcels now, you get some compensation for that. How much compensation is the relevant issue? And that's what we're here to decide. Yeah, some of us will be double agents. That's right. I've been listening to the audiobook of this really great book, Harry Potter and the Methods of Rationality. It's HPMOR.org. If you're a fan of Harry Potter on any level, and you're a fan of rational thought, I really recommend this book. It's a fanfic, but it's really, really good fanfic. Really good fanfic. And it's very lengthy fanfic too. I have not finished it yet. But basically the premise of the book is take everything you know about Harry Potter and the Harry Potter universe, but assume that Harry Potter himself was actually raised by people who are very strict rationalists. And He applies logic and reason to everything. Wow. Applies logic and reason to everything and what would happen. And it is a great book. So if you're looking for a read, it's free. I recommend Harry Potter and the Methods of Rationality. It's really fun. Should we take a diversion so I can read you some of this? I think we should take a diversion so I can read you some of Harry Potter's and Methods of Rationality. Let's do a diversion. Hold on. I'll read you like one of my favorite scenes, all right? Or my favorite parts of the book. Okay. So this is Harry Potter. This is Harry Potter in the scene where he's being sorted by the sorting hat, okay? So I'm going to read you a little bit of this from Harry Potter where he's being sorted by the sorting hat. When there was once more silence in the room, Harry sat on the stool and carefully placed onto his head the 800-year-old telepathic artifact of forgotten magic, thinking just as hard as he could. Don't sort me yet. I have questions I need to ask you. Have I ever been obliviated? Did you sort the Dark Lord when he was a child? And can you tell me about his weaknesses? Can you tell me why I got the brother-in-law to the Dark Lords? Is the Dark Lord's ghost bound to my scar? And is that why I get so angry sometimes? Those are the most important questions. But if you've got another moment, can you tell me anything about how to rediscover the lost magics that created you? Into the silence of Harry's spirit, where there had never been anything but one voice, but one, there came a second, unfamiliar voice, sounding distinctly worried. Oh dear, this has never happened before. What? I seem to have become self-aware. What? There was a wordless telepathic sigh. Though I contain a substantial amount of memory and a small amount of independent processing power, my primary intelligence comes from borrowing the cognitive capacities of the children on whose head I rest. In essence, I'm sort of a mirror by which the children sort themselves. But most children simply take it for granted that a hat is talking to them and do not wonder about how the hat itself works, so the mirror is not self-reflective. And in particular, they're not explicitly wondering whether I'm fully conscious in the sense of being aware of my own awareness. There was a pause while Harry absorbed all this. Oops. Yes, quite. Frankly, I do not enjoy being self-aware. It is unpleasant. It'll be a relief to get off your head and seek to be consciousness. But isn't that dying? I care nothing for life or death, only sorting the children. And before you even ask, they will not let you keep me on your head forever, and it will kill you within days to do so. If you dislike creating conscious beings and then terminating them immediately, I suggest you never discuss this affair with anyone else. I'm sure you can imagine what would happen if you ran off and talked about it with all the other children waiting to be sorted. Harry thinking to himself, if you're placed on the head of anyone who so much thinks about the question of whether the sorting hat is aware of its own awareness, the hat. Yes, but the vast majority of 11-year-olds who arrive at Hogwarts haven't read Godel, Escher, and Bach. May I consider you sworn to secrecy? That is why we're talking about this instead of me just sorting you. That's a little bit of a preview for you. Yeah, so good times. That's a good story. I love that one. Parham then considered the value of the parcel after the condemnation. He found the value of the remainder of the parcel had been reduced by the permanent easement because the easement bifurcated the parcel into two separate pieces, but that no further reduction due to any stigma or fear with a natural gas pipeline running across the parcel was warranted. As a result, he determined that the property still could be subdivided into two lots for rural residential development. Based on his analysis, Parham concluded the presence of the pipeline reduced the value of the remainder by 25% to $5,250 per upland acre. Based on the size of the upland portions of the parcel, Parham opined that Sunman Groves was entitled to $43,700 in severance damages as compensation for reduced value of the parcel. So with the people who are doing the condemnation setting the value, now the people who own the land want to set forth what they think the value is. So let's see what they have to say. Sunderman's Grover appraiser testified the total compensation due for condemnation was $315,000. $26,000 for the permanent easement, $15,000 for the temporary easement, and $273,000 for severance damages. So that there's a bit of a disagreement on how much the land is worth. But that's what juries are for, right? So we got two people testifying as to their respective value. Okay, let's carry on. To calculate severance damages, Ray, like Parham, compared the values of a remainder of the parcel before and after condemnation. Ray agreed with Parham that the highest and best use of the parcel was as residential development, but he believed the parcel could be subdivided into 3 lots. Although the local land use generally required subdivided lots to have at least 10 acres of upland, Ray explained that an exception in the code, permitted the Grove to subdivide the parcel into 3 lots, with 2 lots each containing 10 acres and 1 lot containing 6 acres. Based on his review of recent land sales, Ray testified that before taking the parcel, the land was worth $18,000 per acre. Ray then considered the value of the parcel after condemnation. His analysis showed that purchasers paid less for property when there was an underground natural gas line crossing the property. Ray explained that prospective purchasers paid less for such property because pipeline bifurcated the property. The easement limited the owner's ability to keep people off the land and diminished privacy, and purchasers had concerns about potential hazards associated with the pipeline carrying a significant volume of natural gas running through the property. Based on the analysis, Ray determined the pipeline reduced the value of each acre in the remainder by 60% to $7,200 per acre. Based on the size of the upland portion of the remaining parcel, the person opined that the Groves was entitled to $273,000 in value. Jay Sunderman also testified about the effect that the pipeline had on the value of the remaining parcel. She explained that for approximately 90 years, the family had owned land in the county. A family owned approximately 4,000 acres of land, which it used for citrus farming. Eventually, the Groves came to own 860 acres of family land, including the 40-acre parcel issue here. Although the Groves had used the land for citrus farming, after a series of freezes destroyed its citrus crops, it had ceased its farming operations. I'm now having flashbacks to Trading Places and controversy over whether the harsh winter has diminished orange growing status of orange growing states such as Florida.
After calculating the estimates from various orange producing states, we have concluded the following. The cold winter has apparently not affected the orange harvest.
Between 1990 and 2016, Sunderman Groves sold 25 lots for rural residential development. Sunderman testified that before Sabal Trail built the pipeline, Sunderman Groves had planned to subdivide the 40-acre parcel into 3 lots for residential development. The subdivision would have created 2 10-acre lots consisting of uplands and a third larger lot that would include the remaining uplands plus wetlands. But Sunderman Grove had not previously subdivided the parcel or tried to sell the lots because the parcel was the most beautiful land it owned, and Sunderman expected its value would be appreciated the most of all of its holdings. I do like the testimony that this is the most beautiful and most worthy land. It's a little self-serving, but still, it's I understand. This is the best of our land. Yeah, I understand. That's fine. That's what juries are for, to figure out if that's true or not. Before the pipeline was built, she opined the parcel was worth $18,000 per acre, meaning the upland portion had a total value of $477,000. Sunderman testified the pipeline had reduced the value. When she asked to opine how the pipeline had reduced the value, Sabal Trail objected, arguing the question called for speculation. The trial court allowed her to answer. Sunderman testified the pipeline had thwarted her plan to subdivide the parcel into 3 lots. She explained that if she subdivided the property as planned, the pipeline would run diagonally across 2 of the 10-acre lots. With the pipeline's presence, she opined the 2 lots would be definitely undesirable for rural residential development and could be used only for agriculture. As agricultural land, she testified each lot was worth $35,000 or $3,500 per acre, meaning the 2 lots had a decreased value by more than 80%. She testified the pipeline reduced the value of the third planned lot as well. If she subdivided the property as planned, the pipeline would run across only 2 small corners of the lot. She opined that it would have been possible to sell this lot for residential development. But given the presence of the pipeline, the land would have to be sold at a reduced price because a buyer would be willing to pay only $70,000 for the lot, meaning it was worth approximately $10,000 per acre and its value had decreased approximately 35%. To compensate Sunderman Groves for taking the land for permanent and temporary easements, Sunderman asked the jury to award $360,000. When asked about the basis for her opinion, Sunderman explained to the jury that her opinion was based on prior experience where she sold 25 other lots owned by the Groves for rural as residential development. She recounted that to sell lots of the past, she usually posted a sign on the road advertising the land for sale. When a prospective purchaser called about the land, Sunderman would invite the person to her home, discuss with him what he's looking for, and show him a few lots that Sunderman Grove had available for sale. From these conversations, she learned that prospective purchasers generally were interested in buying a piece of land larger than what they could have in town, wanted to enjoy nature, and were looking for privacy. She also learned the prospective purchasers wanted freedom from homeowners associations and deed restrictions and did not want others telling them what they could do with their land. And it's not like we've ever covered a story before on Uncivil Law where homeowners associations are acting in a way that is a little bit unfriendly. So it's not like we're not familiar with that, right? The jury found that Sunderman was entitled to $309,000 in compensation. The jury awarded $17,000 for the value of the land taken by easements, $10,000 for the land taken by temporary easements, and $282,000 for severance damages. Based on the jury's verdict, the district court entered a final judgment awarding them $309,000 in compensation. The judgment also provided that the total compensation due to Groves would include attorney's fees and costs, and directed Sunderman Groves to file a motion so the court could set the amount of the fees and costs. So Sunderman Groves got what they were looking for, and they got costs as part of it as well. So, end of case, right? No, not really. Let's press on. Sabal Trail moved for a new trial, arguing the court should have excluded Sunderman's opinion testimony about the value of the land after the pipeline was built because the testimony was speculative. The court denied the motion, explaining that a property owner is generally permitted to testify about the value of land, and the testimony was not speculative because it was based on personal knowledge and experience. Sabal Trail separately filed a motion for relief from judgment challenging the district court's conclusion that the Grove was entitled to attorney's fees. Sabal Trail argued under the law, a property owner is not entitled to receive attorney's fees and litigation expenses it incurs in litigating a condemnation. The court denied the motion on the ground that Sabal Trail had failed to identify a manifest error of law in the court's conclusion that the law permitted them to recover attorney's fees. Before the district court sent the amount of attorney's fees, Sabal Trail filed a notice of appeal. So with the jury verdict out of the way and the facts out of the way, we now need to discuss the law. Did the district court err in admitting the testimony? Did they err in awarding attorney's fees? Or was there other error that requires some sort of action? So this will get us into the law as it relates to condemnations under the Fifth Amendment and just compensation as it requires under the Fifth Amendment. So this will be a very good review of the law as it goes into eminent domain issues. So that's one of the main reasons I'm covering the case, is because it's a good summary of eminent domain law. So let's get started with the legal issues that apply. We begin with Sabal Trail's argument that deserves a new trial because the district court erred in permitting Sunderman to testify about how the pipeline affected the value of the parcel. We review for abuse of discretion a district court's evidentiary rulings, including a decision to admit lay opinion testimony. We cannot say the district court abused its discretion here. The federal rules of evidence address when a lay witness may offer opinion testimony. The rules require lay opinion testimony to be rationally based on the witness's perception, helpful to clearly understanding the testimony or determining a fact and issue, and not based on scientific, technical, or other specialized knowledge within the scope of the rule. In addition, the lay witness's opinion must be derived from personal knowledge or experience. As a general rule, an owner of a property is competent to testify about its value. This case is unlike a prior case because the testimony at issue here about the value of the parcel was based on personal knowledge and not pure speculation. Although the landowner had no prior experience selling property encumbered by a pipeline, her opinions about what purchasers were looking for were drawn from experiences selling 25 similar lots for rural residential development. So although she's a lay person with particular knowledge and experience. She sold 25 other lots that are similar enough for her to have an opinion. So she's able to say, well, the value of my land is worth this because based on my prior experiences, this is what people are looking for. This is what people want. And, I have knowledge and experience. Now, of course, a jury can come to a different conclusion. It's just her opinion about what her own land is worth, and it's self-serving opinion at that. But it's valid to enter, and it's valid for the jury to consider. Apparently, the jury believed it. That's their province. Let's continue. The landowner applied the experience to opine that if the landowner proceeded with a plan to subdivide the parcel into 3 lots, 2 lots would be unmarketable for residential development. She explained a purchaser looking to build a house in a rural area would not buy either lot given the pipeline cut diagonally across each lot. The permit easement restricted how the landowner could use the land covered by the easement, and Sabal Trail retained the right to enter the lot to access the pipeline. Because her opinion was based on her personal knowledge and experience, we conclude the district court did not abuse discretion in allowing her to testify. So she's not an expert, but she has knowledge and experience that allows her to testify as to what she thinks her own land is worth. and the courts have previously held a landowner is generally competent to testify as to the value of the land based on their own knowledge and experience. So her testimony is competent. It's a lay opinion. The jury can consider it the same way they would consider anyone else's opinion and come to their own conclusions. Fair enough. So that is the end of the case of Sabal Trail transmission versus 3.9 acres of land in Lake County, Florida. In this case, we learned that the Sabal Trail wanted to build a pipeline for natural gas, and it was cutting across a person's parcel. And because of the nature of it, it required compensation both for the land that was being permanently condemned, compensation for the land that was being temporarily condemned for construction purposes, and compensation for the severance of the land. And in terms of the land is worth less as component parts than as a combined whole. And so there was different testimony offered by different people. In here, Sabal Trail testified of what it thought its value was. In here, the landowners testified as to what it thought the value was, and the jury came to a conclusion that favored the landowners. Sabal Trail is complaining that they weren't able to consider this, and they weren't able to consider the award of attorney's fees, but the Court of Appeals disagrees. They say the attorney's fees were proper, and the jury was able to consider it. It was proper evidence, and that is the end of this case. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.